Podcast sponsorship by Stanford Healthcare, which now has exceptional Stanford Medicine-affiliated primary care doctors located throughout the greater Bay Area. To find one near you, go to stanfordhealthcare.org/local doctor.
From KQED Public Radio in San Francisco, I'm Mina Kim. Coming up on Forum, a proposal from two state lawmakers and a report by KQED are putting the spotlight once again on California's bail system. In Santa Clara County, prosecutors have been cracking down on the practice of bail agents illegally using longtime inmates to direct new inmates to their bail bonds companies.
As a prosecutor for 17 years working on some of the most serious cases in our office, I had no idea how little I knew about bail and how it was being practiced in our county and in other counties.
The incident is just one of many reasons some groups are pushing to do away with a cash-based system altogether. We look at California's bail system and debate potential changes next on Forum after this. From KQED Public Radio in San Francisco, welcome to Forum. I'm Mina Kim. More than 60% of people sitting in California jails have not been convicted of a crime. And among the reasons they're detained is they can't afford to bail out. That's led some state lawmakers and civil rights groups to push for reforms to the state's bail bond system. They say the state's exorbitant bail rates promote illegal schemes like the one uncovered in Santa Clara County, and that people should not be detained simply because they can't afford to pay. But bail agents argue that a cash bail system ensures people show up for trial and protects the taxpayer. In this hour of Forum, we discuss the current state of California's bail system and debate potential reforms. With me is Suki Lewis. She's criminal justice reporter for KQED. Good morning, Suki Lewis.
Good morning, Nina.
Also with us is Margaret Dooley-Samueli. She's director of criminal justice and drug policy at the ACLU of California. Good morning, Margaret Dooley-Samueli.
Good morning.
Good morning also to Jeff Clayton, Executive Director of the American Bail Coalition, representing the California Bail Agents Association. Good morning, Jeff Clayton.
Good morning.
Thanks to all of you for being here. And I'd like to start with you, Suki Lewis. Could you just quickly lay out what bail is?
It's basically a way, if you get arrested for a crime, to make sure you show up to court. And so for a minor offense, a judge can say, okay, just promise us you'll show up, and that's it. You don't have to pay anything. For a more serious crime, they usually set a money bail amount, unless it's really, really serious, in which case they can hold you without any bail at all and decide, that you don't have a chance to get out of jail before trial. And so that's where, if you do get a money bail set amount from the judge, that's where a bail agent usually comes in, because you can't afford the full amount. You pay them a fee. They guarantee the court that you'll show up to trial.
And the median bail amount in the state of California is $50,000. How does that compare with other states?
California has some of the highest bail in the country.
So, Suki, you have been looking at an investigation into the Santa Clara County jail system. Can you tell us what scheme you basically found operating in the jails?
So back in August of 2015, there were 31 bail agents who were arrested by this investigation that the DA launched there. And what they were doing was using inmates inside the Santa Clara jail to funnel them business. So a new inmate would get booked into the county jail, and an inmate who was already there would say, hey, I've got the guy for you, come with me, and then call the bail agent and say, I've got an inmate for you, and basically kind of be the go-between between them. And, from some evidence, it seems that some of these inmates were even kind of threatening the incoming inmates to go with particular bail agents or coercing them or promising them, like, if you go with this person, you're going to get a super sweet deal, and kind of controlling their access to the phones. So they couldn't call their mom to bail them out. They couldn't call a different bail agent. They had to go with the recommended bail agent that the inmate was setting them up with.
And why would a new incoming inmate be susceptible to these persuasions, I guess, by longtime inmates?
Well, if you're a new inmate, like a lot of times, say you haven't ever been arrested before, and you're scared, like you just want to get out. And here's an inmate who's like, here, I can show you the ropes, blah, blah, blah. But also they're being, somewhat coercive. And it's, the danger of it in some cases is that this new inmate who's vulnerable can end up paying bail when they wouldn't have to pay bail. Like if they go through the the county's pretrial risk assessment program, they could have basically no bail set for them at all. They could be released on their own recognizance, or they could have their bail reduced. And they don't know this, so they end up kind of in this potentially bad bail deal. And then it also sets up this kind of weird predatory practice within the jail where there are kind of inmates controlling the phones, controlling other inmates, and getting often free phone calls or financial recompense from bail agents. So they have this financial stake in whether someone is released or not, which is a bit weird, right?
How widespread was this? How many bail agents were involved in Santa Clara County?
So there were 31 agents. From the case files that I've looked at, there were 30-plus inmates involved as well. And when I spoke to the prosecutor who was prosecuting these cases, she said they had to limit the scope. They were so surprised at how much information came back from their original search warrant that they basically stopped looking because they couldn't, it was already, the scope of it was already so large. And that's just in Santa Clara County. So there have been other cases of this in Orange County, San Bernardino, Los Angeles, and from kind of anecdotal evidence, I've heard, Redwood City, other places where this is quite common as well.
Jeff Clayton, you represent bail agents. Curious to get your reaction to this.
Well, certainly we're aware of what happened in Santa Clara County. Certainly, I think they've only, from what I can tell, gotten a handful of convictions or one conviction from what I could tell. But certainly market pressure does cause this. And I think the one thing that I have a problem with is the fact that in California they're treating this as a felony instead of trying to yank the licenses of the wrongdoers. And that's the real problem that we're seeing, is that we've criminalized the insurance code in California to the degree that we've made it so hard to actually get the bad actors out of the business that, because we're treating them as a criminal prosecution rather than simply revoking their licenses. And I think, the economics of bail in California is driving a lot of this. Bail agents about a dozen years ago were swept into what's called insurance premium rebating, which means they could charge very little for a very large bond. And that, I think, is causing the judges to set the bails even higher because it's a buyer's market for bail. And I think that's creating incredible economic pressure on bail agents. We've been working with the Department of Insurance to get them additional resources, and we're hopeful that we can deliver a package on that, because certainly soliciting, can cause a consumer injury. It doesn't every time. But also it encourages gang activity in the jails. And certainly I think the sheriffs also need to do a better job of policing this. If people are being denied their phone calls, that's certainly a civil rights issue. Well, it needs to be corrected.
Jeff Clayton, let me just jump in here, because you've said a lot of things, and I just want to bring Margaret Dooley-Samueli into this. Do you think that a felony is too harsh a punishment? What are the effects on people's lives of being lured into one of these bail schemes?
Well, it may not.
No, I'm sorry. This was a question for Margaret Dooley-Samueli.
We have a system that allows people to be locked in jail because they can't afford to buy their freedom. So this is clearly a system that doesn't work. Even if bail is lower, there are still people who cannot afford to pay. And the decision for whether or not you should be able to return to your life while your case is pending and you're fighting your case, your ability to do that should not be linked to your wealth or your the amount of money that you can come up with.
And Suki Lewis, was there only one conviction? Your
No,
understanding is different.
That's incorrect. A number of plea deals. Most of the agents have settled for plea deals. A lot of them were for community service, but there has been jail time too. The harshest sentence was for 4 months in jail, and there was another man who's going to spend 3 months in jail. There are 7 cases still outstanding that may go through the trial process.
And what were the effects on some of the people who were lured into some of these schemes?
I don't know, to be honest. I've been trying to contact people, and you kind of get anecdotal evidence, but I haven't been able to get in touch with these inmates. And, some of them quite rightly are afraid to talk to me. I talked to bail agents and said, will you, put me in contact with some of these inmates who say they were being threatened, and they said no, they're afraid.
Do you agree with Jeff Clayton's assertion that it's a harsh punishment for the crime?
I don't think I want to comment on that. I don't rightly know. Like, that's a decision for policymakers. And I think, from what the prosecutor was saying, I think there could be significant improvement to the Department of Insurance code. It's apparently quite confusingly written. But bail agents have to take a test. Well, it was every year. I believe now it's moving to every 2 years, where they get kind of grilled on what the rules are. So bail agents did know that they were breaking the rules.
And again, we're talking with Suki Lewis, criminal justice reporter at KQED, Jeff Clayton, executive director of the American Bail Coalition, who represents California bail agents, and Margaret Dooley-Samueli, Director of Criminal Justice and Drug Policy at the ACLU of California. And Margaret Dooley-Samueli, you were starting to say this, but essentially you were describing a system that a cash bail system is essentially unjust and ineffective. What changes would you like to see?
Well, we should absolutely end the practice in California of denying someone's liberty based solely on their wealth. What we should have, and what many Californians are surprised to learn that we don't already have, is a system that evaluates whether people will return to court as required to deal with their case, and whether it's safe for people to return home when that happens. So it's a public safety question and it's a return to court question, not how much money do you have in your pocket. We don't have to start from scratch in California. Several counties in California are already moving in this direction, Santa Clara County, for example. But there are also states that have tried this before. So we have a lot of proven methods to learn from and improve upon and make work for California.
So when you say this, you mean alternatives to a money-based system that still ensures that people show up to court?
That's right. So money bail is supposed to work as an incentive to return to court. But, of course, it doesn't do that at all if it means that thousands of Californians are detained and don't get to return home. What we need is a system that other states have tried, that we can absolutely implement here, that will return to those goals of getting people to court, protecting public safety, while also protecting the liberties of Californians.
Suki, you have looked at how the system has played out and have described the legal bail system as pretty tricky. Can you say what you mean by that?
Well, the legal bail system is just very interesting. I mean, I got kind of fascinated with this as this weird part of the criminal justice system that is kind of outside of the purview of courts and regulators, and so the judge sets the money bail amount. They think one thing is happening, and in practice, often something quite different is happening.
So the judges think what is happening?
So the judges think, okay, I've set your bail. You committed this, violent felony. You have this history. I'm going to give you a really high bail amount. There's no way you're getting out. And in fact, oftentimes that defendant can call a bail agent and, even Jeff Clayton was kind of referencing this earlier, get out for a fraction of the total bail amount. So they can get on this payment plan system. They're like out of jail for a few $1,000s, which is, from a public safety standpoint, kind of shocking. And then from that point on, that contract is between the bail agent and the individual, and nobody really knows what the terms of that are and what happens, with that individual.
Jeff Clayton, can you address the public safety question that Suki Lewis is raising?
I think it could be a public safety question because judges are making certain assumptions about what types of security, and you got to remember, most of these bails are posted by third party. What type of involvement are you going to get from a third party in this transaction? And when the judges don't know, and I call it sort of truth in bail in California, is nobody knows, as Suki was saying, and that is problematic because in other states there's floors. There's some states that require the full premium to be collected before a bond can be posted. And what that does is create transparency. Judges, everyone sort of knows, okay, there is going to be some minimum that you have to meet to get out. Connecticut, for example, being 35%. So that definitely creates a problem in terms of judges making assumptions about people and behavior and incentives that maybe aren't there.
So you would be behind more transparency in those types of contract arrangements?
Well, Well, yeah, absolutely, and I think it really needs to come from state statute that sets a floor on this in terms of, how little can be charged, and so that there's some disclosure, to the judge. And certainly we need to correct this market imbalance problem, I think, is the biggest issue in California.
So you don't want to see a cash-based bail system go away. What is the value of it to you, Jeff Clayton?
Well, I think one national researcher said bail agents are the true long arms of the law. I think really it's about appropriateness of cases. And usually bail agents do their best work in high-risk cases where the person otherwise wouldn't be able to get out. We don't do as good a work in some of these lower-level cases. And so, to me, it's the art of bail is making the adjustments to the system. And California certainly has a lot of adjustments that can be made and certainly that we're advocating for.
Margaret Dooley-Samueli, would you be okay with a reform that it still included a cash-based system?
What we need to make sure is that nobody gets stuck in jail because they can't afford to pay. In California right now, there is no consideration of ability to pay when bail is set. So that's certainly not going to work. In other states, money remains, and unfortunately, even at very low bail amounts, you still have a problem of people detained simply because they cannot come up with even $100, $200, $300. So the real critical piece here is what's the deciding, what's the determination and how is that determination being made about whether a person can return home while awaiting the outcome of their case or not. And that cannot be money.
Do you think, so describe for me what you would replace it with in your ideal world?
Well, money bail has really become increasingly common in just, say, the last 20 years. Before that, and as we're seeing in states that are doing this now that have reduced their reliance on money bail, like New Jersey, what you have is more information to the judge early on so the judge can make a much more informed decision about whether you can be released on your promise to return. Most people can be released on a promise to return. The judge may, with that additional information, the assessment of this individual, that judge has information to decide, I think we need a little bit more assurance in your case. We're going to have require some conditions, say that you're going to have to call into a pretrial services agent once a week or even daily. And one of the most effective things that research has found is that if you just remind people the day before their hearing, their date at court, they'll show up. Just like the dentist, just like your hairstylist, just that reminder call dramatically increases people's return to court.
What about people who have a very serious, violent felony charge? Are these practices that other states use for people with that level of, level of concern by the judge?
Well, all the more so because right now judges have very little information on which to set bail or make release decisions, and in most cases they are setting bail according to a menu, basically, that has been predetermined. Again, it has very
bail
little
schedule,
to do,
you mean?
Right, the bail schedule, and it has very little to do with the individual. So there is little risk, really, little information about risk that the judge has at that point. Let's also remember that a person has been arrested for something, accused of something, but has not gone through the process for that to be found true or not. So it's very important that we not skip over the fact that these folks are presumed innocent. They have not been proven guilty, and they are owed their day in court and their ability to build a defense. Now, if a person is dangerous or poses a real risk, that the judge doesn't currently know because they don't have that information. With an individualized assessment of each defendant, the judge will have that information and be able to act to set conditions or deny release according to real factual evidence and not an accusation.
Suki Lewis, earlier you mentioned a pre-trial release program, and I think you even reported on one in Contra Costa County. Can you describe that program?
Well, yeah. So each county, some counties have been looking at this in California, not every county, but each county is kind of implementing them differently. So you go from one county to another and you'll find a slightly different system. But it's kind of based on this idea that Margaret is talking about risk assessment. So a new arrestee comes in. They get their information kind of entered into this like computer code that's like looks at various factors. Are you employed? Do you have
previous
ties in the community? Do you have previous drug use? What is your crime? And then that gets kind of printed out and given to the judge for consideration. And in some places, this is kind of taking the place of money bail. So this risk assessment is instead of having a higher bail amount because you're considered, because you have a higher crime, you get a higher risk assessment. And so you have more conditions placed on you pre-trial, but you can be released and potentially keep your job and keep, if you have children, keep relationship going with your children. And so it can have this positive benefit for people, and those who are proponents of it say it can also save taxpayers money because that individual is not then in custody. So we're not paying for them to be in jail.
And just give us a sense of what it costs for someone to be in custody and what it costs for this program.
We don't rightly know what the risk assessment program, if it were to completely replace money bail, we don't know what it would cost. And I'm sure Jeff Clayton will tell you, what his numbers are, because there are very different numbers depending on which side of this you're looking at it.
Jeff Clayton, the cost of someone being in custody is about in the state of California.
Nationally we look at it around $200 a day. Is sort of a good rule of thumb.
And these types,
I don't know. I think it varies based on the jurisdiction in California.
Yes, I think I've also seen a range of numbers anywhere from like $118 to what you're saying. And then Margaret Dooley-Samueli, what generally is the cost of implementing these types of, pretrial assessment programs?
It really depends how you design the program, but there are certainly, you're looking at under $10 a day per person is I think the Kentucky rate. So it depends how many services you have available, but it's certainly, a tiny fraction of the alternative, which is to keep people in jail.
And so, Lewis, do you know how successful this program has been at Contra Costa County in terms of people returning to their court dates?
It's been quite successful in Contra Costa. Santa Clara also has this program. I think it's about in both counties, it ranges, between 90 to 97%. And that's for people who do not commit a new crime and who show up to court. But I will have a caveat with that, which is that they're only in Contra Costa, it's a very small range of offenses that you can be eligible for straight pretrial release without bail. So it's kind of a self-selecting number at this point. It's not from the total pool of inmates charged with a variety of crimes.
Well, let me invite our listeners to join the conversation. We're looking at California's bail system and debating potential changes to it with Suki Lewis, KQED's criminal justice reporter, Margaret Dooley-Samueli, Director of Criminal Justice and Drug Policy at the ACLU, and Jeff Clayton, Executive Director of the American Bail Coalition. What are your questions, comments, experiences with the bail system? Give us a call at 866-733-6786. Again, that's 866-733-6786. You can also email your questions to forum@kqed.org, post them on our website, post them on Facebook or Twitter. After the break, we'll talk with the state lawmaker who is introducing reforms to the California system. I'm Mina Kim. Stay with us.
Support for KQED comes from the Climate One podcast, changing the conversation on energy, economy, and the environment. Podcasts at climateone.org.
Support for KQED comes from Earth Justice. When the environment is threatened, the courts often stand as the last line of defense. That's why Earth Justice uses the power of law to fight for clean air and water, healthy lands, and wildlife. With more than 100 attorneys nationwide, Earth Justice gives voice to clients who need a lawyer, from farm workers poisoned by pesticides to endangered wolves threatened by hunting. Text JUSTICE to 52886. Earth Justice, because the earth needs a good lawyer.
Welcome back to Forum. I'm Mina Kim. A proposal from two state lawmakers and a report by KQED are putting the spotlight once again on California's bail system, and we're taking a closer look and debating potential reforms with Margaret Dooley-Samueli, Director of Criminal Justice and Drug Policy at the ACLU of California, Jeff Clayton, Executive Director of the American Bail Coalition, representing the California Bail Agents Association, and with Suki Lewis, Criminal Justice Reporter at KQED. And also joining us now is Assemblyman Rob Bonta. Assemblyman Bonta, thanks for joining us.
Thanks for having me. Thrilled to be here. Thank you.
Yes, you're the author of AB 42, which is the Assembly version of Senator Bob Hertzberg's SB 10, the California Money Bail Reform Act. I understand that it wasn't fleshed out when you introduced it. Is it fleshed out now? What would it do?
Yes, we're on the verge of having the fleshed out language and the specific policy approach to the problem that we see. Right now we have a broken money bail system, and it needs to be fundamentally transformed. We have a system that punishes poor people for being poor and makes determinations about whether you will sit in jail or be released back to your family and the community based on how much money is in your pocket instead of how much risk you pose to the community or the threat that you pose to not show up for your next hearing. And we think there's a better way. There have been better approaches done in other localities, such as Kentucky, New Jersey, Washington, D.C. In some of these localities, these approaches have been done for years. And so our general conceptual approach will include the following. We will have a pretrial risk assessment that determines accurately how much of a threat you are to the public and how much of a flight risk you are, meaning how much of a risk you are to fail to show up for your next hearing. And it will encourage folks to safely be returned to their families and into the community. It will also have a pretrial services component where, with appropriate oversight and accountability components, folks can be released from custody and into the community. For example, electronic monitoring could be a way to assist someone in being released from jail pretrial. And then finally, conceptually, there will be a component for bail, but it will be a last resort, and it will be only set at an amount that an individual can pay. So you won't have what we have now, where we have thousands of people sitting throughout the state in jail simply because they can't afford to post their bail. Bail that is on average $50,000. The general formula is that 5% of that is non-refundable if you use a bail bond service. So that's $5,000 that folks would need to post and lose from their pocket just simply to go back into the community. And we think what we've been doing is fundamentally wrong, not working, unfair to the individual who is discriminated against for being poor, unsafe to the community because we're not using appropriate metrics to determine who should be released. It's simply based on the amount of money in your pocket, and it's extremely costly. We're spending about $4.5 million per day to house in jail individuals who have not been convicted of anything, and many of whom are there simply because they can't post bail. So there's a trifecta here where we can have a win-win-win, provide greater justice to the individuals, provide greater public safety, and be more prudent in our spending as a state.
And have you put a cost to this in terms of the risk assessments, the monitoring? I know you just gave us the cost of what it is to keep people in jails.
Yeah,
your program.
The cost will be less than what it costs to put people in jail. We don't have an exact costing yet. That analysis is still to come. But certainly with pretrial services, there is a cost to it to provide that oversight and that service and that program to help ensure that individuals are released when it's safe to do so. So, but overall, it will be, while there will be a cost to the pretrial services, the savings will be greater, certainly in the long term, and we believe also in the mid and short term, from going this route.
Are you getting any pushback from the bail bonds industry? It could potentially put a lot of people out of work?
Of course, the bail industry is opposed. Generally, they believe that the status quo should continue, but I would also say there is some very productive conversations going on with some members of the bail industry regarding appropriate reform and different approaches. So certainly, I think some see this as a change that's not good for their industry and the status quo. So they're opposing. But I'm pleased that some folks have been open-minded about being part of productive discussions to improve our broken system.
It sounds like you're saying then that cash bail will still be part of this program. Will be part of the system.
It will not be entirely eliminated. Its role will certainly be reduced in the conceptual approach that we're proposing.
And the timeline of this legislation, Assembly Member?
It's this year. We're moving it now. We're going to be in our first committee in a couple weeks, and we have the two bills, as you mentioned, both Mr. Hertzberg's and mine, moving on dual tracks at the same time in the two houses of the legislature. And by the end of the year, we hope that these bills will be on the governor's desk, ready for signature.
Well, Assemblyman Rob Bonta, thank you for talking with us. We really appreciate it.
Thank you for having me. I really appreciate it.
Thanks. Jeff Clayton, are you for or against this?
Well, we haven't seen the language yet. Certainly, we've been talking to the Assemblyman and certainly Senator Hertzberg, both two of the most reasonable people you'd want to deal with. And, we have our own ideas of what we think should be included in terms of bail reform. There are things like due process reforms, because the reality is there's no consideration of any factors when a bail schedule sets bail. You need individualized consideration quicker in California, and you need more of it. And frankly, we think you probably ought to even consider getting rid of bail schedules and just having a judge set bails. There's other things that we're proposing, and we don't oppose the general idea that, we don't want these poor people who can't afford bail in jail. I think California is fairly progressive in terms of the people in California's jails are typically more severe offenders than other states. But that being said, we do recognize that there is this situation, and we think, the existing pretrial programs throughout California now, giving OR bonds and having judges within 48 hours considering people's ability to pay. And frankly, most state statutes around the country require some consideration of resources, whether it be employment, housing, that sort of thing, as a consideration for bail. So really, we think judges need to get as folks have said, better information on what's going on. And certainly, concerning the risk assessments, we think there need to be safeguards for the use not only of risk assessments, but the impact on defendants' rights of all these ankle monitors and that sort of thing. Because what we're finding out is these non-monetary conditions of bail could be more restrictive on someone than a bail if they're able to afford it. So that's an important consideration, I think, as well.
Well, I want to bring our listeners in, but Suki, you said you wanted to rejoin here.
I was just going to say, yes, pretrial risk assessment does have some concerns with it as well, including the fact that it can take quite a long time. So if you're in jail and you want to get out right away, that's one of the big arguments that kind of bail agents make is we can get you out right away. You don't have to spend the weekend in jail. And so I think in order for pretrial risk assessment to really kind of compete on that level, it needs to, get more speedy and kind of more effective in terms of how they assess people.
Well, let's hear from Helen in Texas. Hi, Helen.
Hi. I've been 25 years, a year and a half as a Lubbock County, Texas prosecutor, and 23 and a half years as an assistant federal public defender. The current system helps criminals to get off, because what happens is you charge a poor person and they're sitting in jail 5, 6, 7 months. The prosecutor comes to them and says, hey, if you take this plea, we know we don't have that great of a case against you, but take a plea, you walk out today, wait for trial, you're going to have to wait another 6, 7 months in jail waiting to go to trial. So what it does is innocent people plead guilty so they can get out of jail and take care of their families, and the guilty people who actually committed those crimes go free.
Well, thanks, Helen, for the call. And Margaret Dooley-Samuel, this is something the ACLU has raised in terms of innocent people being more likely to plead guilty. And do you agree with Helen's assertion that it also makes guilty people more likely to go free?
Well, certainly when your determination is based on wealth, then it has nothing to do with your guilt or innocence. And so there are absolutely situations where you have very sketchy people who have access to the money that they need to buy their freedom, and so they can.
And Alejandro asks, when monetary bail is appropriate, shouldn't it be based on a percentage of income or net worth? Otherwise, doesn't it violate the Equal Protection Clause, which is, of course, something that Margaret Dooley-Samuel and other attorneys have raised in terms of the constitutionality of a wealth-based system?
So at the federal level, unreasonable bail does actually, the courts have decided that actually does reflect your ability to pay. Strangely and incorrectly, in California, that's not how that term has been, the courts have interpreted it. Instead, in California, it has to do with whether it is appropriate to the level of the crime for which you have been accused. Doesn't make any sense. Certainly has nothing to do with whether or not it's affordable to you. And so that is one major problem with the system that we have now, where it is absolutely based on wealth, because the setting of bail has nothing to do with how much you can afford.
Well, let's hear from this caller who'd prefer to remain anonymous. Good morning.
Good morning. I just want to make the point that this should be appropriate for all citizens in the system, and not just based on income, whether somebody has income or whether somebody doesn't have income. I was a first-time offender. The case is pending now, and this happened in one of our less progressive counties, shall I say, in the state of California. And I had to think long and hard about whether I had the mental fortitude to stay in jail over a weekend, because of the day that I was arrested was a Thursday, I believe, whether I was going to stay in jail through the weekend or throw away $1,500 into a bail bondsman, which I could have taken that $1,500 and put towards my defense attorney. And I think the ideas that you guys are coming up with are all really sound. If somebody who never thought that they would have to even know anything about this, the system of just reading off of a prescribed list of numbers, 15,000 is the base bail, I believe, is just not an appropriate way of keeping people out of jail. I also want to make the comment that I think you're going to have a hard time convincing privatized jails to go for this, because they make a lot of money per day having people in jail.
Well, I want to thank you for sharing your experience, and, best of luck to you. Suki Lewis, this caller's story is certainly one that you have heard about multiple times. What appetite is there right now from all the different forces in terms of the types of changes that are being proposed? Are you feeling like, you've been looking at this now for 2 or 3 years, are you feeling like there is momentum for change?
There is momentum, and it's not just here, it's across the country. New Jersey just...
New momentum, I should say.
Yeah. New Jersey has been moving away from money bail this year, kind of rolling out their big risk assessment pretrial program, and we'll kind of see how that plays out. And then here locally, there's also been these constitutional challenges to money bail that were brought in federal court, that the San Francisco city attorney declined to defend money bail practices. The state attorney general declined to defend money bail practices. And, under the Obama administration, the Department of Justice kind of filed this brief in one of these cases saying that, money bail or based solely on wealth, if your freedom is based solely on wealth, that is unconstitutional. So it'll be interesting to see how those court cases play out and how that plays into this kind of larger conversation. But it does seem that there is an appetite from the public and from lawmakers to do something about it.
Well, a listener writes, a member of our family was arrested for drug trafficking, but hasn't spent a day in jail because the family has money to easily post bail. And being white doesn't hurt either. This person was unanimously convicted, but is still out in the community while awaiting sentencing. Although the system has worked in our favor, it is profoundly unfair. And Colin writes, let's be honest about the terminology here. This is a product of the theory of public-private partnerships. Preventing crime would put people out of work. This all stems in part from a can't-do attitude in the court system. If there's a problem with no shows to court, the system should have the public answer for it rather than creating an opportunity for money sellers. Suki Lewis, how frequently are bail agents on the hook for the full amount of, for the full amount of bond, right, if the person doesn't show up?
Well, that was one of the things that I found most surprising in kind of investigating and doing, getting deeper into this world of bail, is that it's quite rare that they actually end up paying. There are all these kind of there's quite a high bar that the court has to meet in order to get paid by the bail agent. And there are a lot of different exceptions that the bail company can use to kind of argue that they shouldn't have to pay. And they also have quite a significant length of time. So like if you fail to show up to court, then you get 180 days to find the person, make sure they show up to court.
And who finds that person?
Oftentimes law enforcement finds that person. So so
the taxpayer's footing that bill.
Yeah. Yes. And the county can recover those costs. For example, if someone flees to Florida and law enforcement picks them up there and then calls and says, we have somebody in our county. Do you want to extradite them back to California? And then someone, from Santa Clara, for example, two policemen can go down there and get them and bring them back and what have you. And those costs can be recovered from the bail company, but they rarely are. And it's quite difficult to do it. So it's kind of this funny procedural thing where if you're not dotting all the T's and dotting all the I's and crossing all the T's, you're never going to see that money.
Does the bail industry lobby against laws that make it harder for courts to collect bail money? Because that was something one of your pieces seemed to suggest, Suki Lewis.
Yeah, they have, a quite powerful lobby, and these rules, do benefit them clearly. For some numbers, about 20% of bail go to forfeiture proceedings. So that's the proceedings that begin if you don't show up to court. But it's less than 7% that actually ever get collected. So that's quite a significant difference.
Less than 7%. What do you say to this, Jeff Clayton, as head of the American Bail Coalition?
Well, one, it proves the incentives work. I mean, the agents are liable on every bond that they write, not just when, they go through this forfeiture process. That incentive is alive the second the bail is posted. The idea that law enforcement pick all these up is ridiculous. I mean, the bail agents get so many of these back on track without even having to effect an arrest because of the incentives. And if the argument is that we can simply call people and tell them that they missed court, well, what do you think the agents do when somebody fails to miss court? They call them and they get them back into court. And, the idea that fewer are paid proves to me that it works. And certainly there are some exceptions. And, folks can argue about, whether the incentives should be stronger or whether they should change. To the idea that we have some big, powerful lobby is ridiculous. I mean, we are a really small industry compared to what people think it is. And since I've been at the American Bail Coalition, I'm sure I've worked on a single bill on forfeiture reform. So, we're not trying to make it easier on bail agents. If anything, we want to make sure that the incentives work and that we can get people back. And when we talk about getting people back, I mean, I'm working on cases right now where we're trying to return, two-time rapists from Morocco so that the victims can get justice. And the U.S. Department of Justice and all these government agencies are doing very little to help us.
Suki Lewis, you want to respond?
I was going to say that is something like actually going and getting people. A lot of these bail companies have kind of these extradition teams that go and pick people up in Mexico or Morocco, as Clayton was saying. Bounty hunters, yeah. But they're actually quite good at it, and that is a cost that I think, will have to be taken into account as, if we move away from money bail are we going to, put law enforcement resources into going and tracking these people down? And, I don't think that's always figured into the cost of pretrial release.
Well, can you address Rodney's question, Margaret Dooley-Samueli, which is how is the bail money used by California once collected? Is it refunded? If the defendant is cleared of charges? This is sort of a basic procedural question. Yeah.
Right. The money paid to a for-profit bail agency is never refundable. It could have been a wrongful arrest. You could be found innocent. You meet all your court dates. You will never get a penny of that back. If you were wealthy, though, and you paid the entire amount up front to the court, you would, in fact, get all of that back minus whatever administrative fees were put against it. So, again, if you're wealthy and you don't need a for-profit bail agent, then it's going to be cheaper in the end for you to deal with that bail amount. For low-income people, well, actually, with median bail at $50,000, let's be frank, it's basically everybody else. Most people have to pay a bail agent, and let's be clear about the arrangement here. You are calling from jail, or grandma or your wife is calling from home while you're in jail, and the bail agent has all the information, all the power and people end up signing very these contracts that trap them into debt for years. Even if you made all your court dates, even if you've been found innocent or you're serving your sentence of probation, you may be paying for years. And if you miss a payment, these contracts may say that they can collect the collateral, so grandma's house. So it's a very desperate situation that people are in that lead them to sign contracts that are very detrimental to their long-term well-being and economic future.
You're describing something that sounds similar to predatory lending.
It's very similar. So just like, if you're desperate for cash, you need to buy groceries, you'll go to you'll get a payday loan so that you can go buy your groceries until payday because of that desperation.
Would more transparency in terms of these contracts, you think, help alleviate some of this? I mean, Jeffrey Clayton suggested that he'd be supportive of that.
Regulating, as long as the business exists, it should be reasonably regulated. It currently is not. However, the bigger problem here that we are looking to solve is making sure that lack of wealth is not keeping people locked up. A better or more transparent contract doesn't solve that problem. As long as bail companies are around, we should absolutely have that. And let's be clear about this industry. Bail agents, the mom and pop shops we see, the neon signs, the slogans and pens, that's what we see. And there are thousands of those. Behind them, however, there are a relatively few number of insurance companies, increasingly international conglomerates that are dipping their toe into the bail industry. So the bail agents themselves, they're not getting rich. Where the real wealth and the real power, lobbying power, are the insurance companies. That is really who backs the American Bail Association.
Well, that seems to jibe with what I think we all see when we see these storefronts, is that they don't necessarily look like they're places that could pay hundreds and thousands of dollars of somebody's bail if someone failed to show up to court. I wanted to get quickly, Margaret Samaduli, your response to this question from another listener who asks, why not use ankle monitoring for higher risk, higher crime cases? Seems a lot cheaper and possibly more effective than money bail. I've heard this idea mentioned before, but how come it is so rarely brought up? Even Assemblyman Rob Bonta brought it up, but I'm curious, Margaret Dooley Samueli, how do you feel about ankle bracelets?
Well, there are a whole host of services and techniques and tactics that are used to help support people getting back to court and ensure that people are not getting into trouble while they're released pre-trial. Ankle bracelets can be one of those, but it's expensive. It may not be appropriate, and we certainly don't want to see that overused. That is also a real surveillance technique. And again, we're talking about people who are presumed innocent, so we want the conditions to be appropriate for that person while they are back in the community figuring out their case. So that there are going to be situations where that's going to work. There will be many where that's just not necessary. But the good thing is that's not the only option. There are many, many options that we're seeing used in Kentucky and New Jersey and D.C. that we can look to as models.
Jeff Clayton, I'm curious if you're concerned about new technology putting bail agents out of business or really dampening their business.
Well, yeah, I think it's an issue, and the idea that we're some powerful lobby, that mom and pop shops make 9 out of every $10 in bail. The real issue with these ankle monitors is the reason there's bail reform is because those are publicly traded on Wall Street, and they're selling their wares at local and national county conferences saying, well, hey, you don't need bail because defendants can just go on an ankle monitor, and guess what? They pay for it. They pay for their own supervision. They pay $35 a day in San Francisco County to be supervised, to only then ensnare themselves. You put them on a scram unit, and you tell them to quit drinking, and you don't give them any services, and what do you think is going to happen? They're going to violate. The prosecutor has a hammer. So these non-monetary conditions can be completely onerous on somebody's liberty and can be worse than a simple monetary bail or a release.
Well, let's hear from Anthony in San Francisco. Hi, Anthony.
Hello.
Hi, Anthony. Are you there?
Yes, I'm here.
Go ahead.
Well, my son has been dealing with a case since 2012. He's been out on bail. And I think one of the callers had mentioned about using that money to get an attorney. And
Anthony, I'm so sorry. It seems like your phone line is cutting out, but I guess I wish best of luck to you in your son's case. Let's see if I can get a better phone line from John in San Jose. Hi, John.
Well, hello there. Myself, I've actually been a victim of these particular circumstances where bail was set so ridiculously high for an offense that was just so borderline, be honest. My alcohol content was just below the legal limit, but however, based on the legalities of how to pull a license, if you go ahead and get a alcohol drug screening, that regardless of that one.
I'm so sorry, John. It also appears that your line is having some problems as well. If you could call us back in the last minute, that would be great. In the meantime, let me see if I can grab Kim in Texas. Hi, Kim.
Hi, I'm a licensed private investigator here in the state of Texas, and this is a subject that I think about on a regular basis. I look every day at who's in my local jail, and many of those people, I would even say most of those people, do not probably pose a risk to society at large. Risk assessment is a great first step in trying to overcome this problem. I think that it's not free, but it certainly is cost-effective when you consider the great cost to society of holding these people in jail.
Well, Kim, I thank you for that, and I think actually that's probably a good place to end since this is a show that's discussing reforms. Margaret Dooley-Samuel, I do, though, want to give the last word to you in terms of, are you behind this California effort by the Assembly member? And what role are you playing in it?
Yes, we are. The ACLU is a co-sponsor along with another 8 organizations, all of whom have a really large stake in the success of bail reform in California.
Well, Margaret Dooley-Samuel, thanks for joining us this morning.
Thank you.
And Jeff Clayton, Executive Director of the American Bail Coalition, thanks as well to you.
My pleasure.
And I want to thank Suki Lewis, the criminal justice reporter for KQED. Thanks, Suki Lewis.
Thanks, Mina.
And thank you to our listeners for sharing your stories and your questions. Forum is produced by Irene Noguchi, Judy Campbell, Tina Lauerberg, Jeremy Siegel, and Susan Britton. Our engineer is Danny Bringer. Our engagement producer is Amanda Stupai with online support from Amanda Font. Our interns are Devin Holt and Stephanie Roberts. Our senior editor is Dan Zoll. And Holly Kernan is our executive producer. I'm Mina Kim. Thank you very much for listening.
Funds for the production of Forum are provided by the members of KQED Public Radio and the Germanicos Foundation and the Generosity Foundation, and by a generous gift from Jan Schrem and Maria Minetti Schrem, founders of the Minetti Schrem Museum of Art at UC Davis, who believe that all people deserve access to education and culture to enrich a lifetime of exploration and learning.